morning. Thank you for being here. I'm Workman, Chairman and President of Texans Against High-Speed Rail. Today marks an important day for landowners in their fight to oppose Texas Central's ill-conceived, Japanese-funded boondoggle. I'm proud to be here with my friends, State Representative Ben Leman, landowners Jim and Barbara Miles, Blake Beckham, Texans Against High-Speed Rail Special Litigation Counsel and attorney for the Miles, among other friends and supporters of Texans Against High-Speed Rail, including Judge Deborah Evans and Judge COURTHOUSE. At this time, I'm going to invite Blake to come up and announce the court's decision and its impact on the project. I'd also like to include my thanks for Blake and Patrick McShan of the Beckham Group for their tireless hours that they have donated to make this win a possibility. Blake, thank you.
Thank you. My name is Blake Beckham, and I am the principal in the Beckham Group in Dallas, Texas. With my associate Patrick McShan, we have been privileged to represent Jim and Barbara Miles. Jim, good to see you. Barbara, great day. We are fortunate and honored to represent Jim and Barbara Miles. They are courageous Texans who have stood up against oppression, like many Texans in our state's proud history. The project they stood up against was a Japanese-funded monopoly grab for high-speed rail, and not only in Texas, but in the United States. In 2016, Jim contacted me and he said, I want to fight. I want to fight this project. It's bad for property rights in Texas. It's bad for the state of Texas and its taxpayers, and it's bad for the United States. Jim believed that the project could never be funded with private money, as Texas Central's backers maintain, but instead would become too large to fail and would be a government bailout and a drain on the resources of the country and of our great state of Texas. I told Jim this is going to be a long and arduous fight, and they're going to come after you, and they're going to threaten you, and they're going to intimidate you, and they did just that. They sued him personally and his wife for hundreds of thousands of dollars in legal fees. When we defeated Texas Central in other similar cases in Houston, they created a new entity called ITL that also intervened in this case and sued Jim and his wife Barbara for hundreds of thousands of dollars in legal fees without ever having contacted him, without ever having sent a representative to his property or even contacted his lawyer. So two separate companies backed by the Japanese suing these brave landowners for hundreds of thousands of dollars. Now, what was the result and what was the ruling that we had here in Leon County last Friday? The judge, the court, ruled that Texas Central is not a railroad company and they are not an interurban electric railway. Those two grounds are the only grounds that Texas Central had ever sought eminent domain in order to complete this project. We contested both of those grounds, and we asked the judge to rule as a final ruling of her court. There will be no trial. We asked the judge for a final ruling that Texas Central had no authority to exercise eminent domain, that Texas Central was not a railway company. Texas Central responded with an army of lawyers, almost 200 pages of legal briefing, 7,000 pages of legal exhibits that they claimed proved their point, and 3 hours of argument last summer. Now, all of this argument came after they had lost injunctions in Harris County that we defended to have surveys under eminent domain. They lost a summary judgment in Harris County that they did in fact have the right to survey. In December, they lost 3 separate cases in Ellis County. Texas Central lost, where they claimed as a matter of law that they had eminent domain. But this landmark decision in Jim and Barbara Miles' case was the first time a judge ruled or a court ruled affirmatively that Texas Central had no authority and therefore had no rights to eminent domain. Ladies and gentlemen, this project cannot be finished without eminent domain. And the project is completely off track. The project is stymied, and I don't believe it will ever be built. And that is exactly what Jim Miles wanted to accomplish. That's why he teamed up with me. That's why he teamed up with Texans Against High-Speed Rail to protect the rights of landowners in Texas. Now, it has not been an easy fight. We have, on behalf of Texans Against High-Speed Rail, we have fought Texas Central in the federal government before the Surface Transportation Board. There, Texas Central tried to escape any regulation by the state of Texas and tried to have the federal government take over regulation, but then not regulate them at all. It was a manipulative legal maneuver, just like many others. Texas Central has also tried to manipulate the Federal Railway Administration into giving them a stranglehold or first choice on many safety regulations for high-speed rail, effectively giving the Japanese a monopoly on what could be a crucial piece of infrastructure in our country. They have also filed over 40 cases in the state of Texas. They are a very manipulative litigation opponent. After we defeated them in Houston in the House case on 2 occasions, they dismissed all of their remaining cases in the state of Texas, including their claims against Mr. Miles, and asked the judge to throw the case out. This happened 2 years ago. Mr. Miles said, no, we want to proceed on this fight. Texas Central doesn't get to call the fight off when they want to. We want to continue the fight. So the case has continued on. We've soldiered on. Mr. Miles has had some health issues, but he has never wavered in his desire, along with his wife, to fight Texas Central. And when we continued the fight, then Texas Central reversed their course once again and started filing other lawsuits across the state of Texas, including the ones in Ellis County, which they recently lost. So I commend and compliment Jim and his wife Barbara on their courageous action in the face of a giant Japanese company with an army of lawyers with hundreds of millions of dollars at their disposal and seeking attorney's fees against him, which would surely bankrupt him if they won. And he never backed down, he never flinched. In fact, much like his Texas forefathers that told enemy forces to come and take it, Mr. Miles told Texas Central the same thing. Try to come and take my land, and I will fight you if it kills me. And today, he's here to claim victory, not only on behalf of himself, but on behalf of landowners all over the state, the great state of Texas. And with that, I know Barbara and Jim would like to say a word or two. And I'm going to drape Jim in his battle flag. There you go, buddy. Keep it warm.
Thank all of you for being here. It's a really special day for us. We could talk all day about this victory and what it means to us personally and to the citizens of the state of Texas, but just bear with me for a couple of minutes by offering you this statement. Acreage, property, farms, ranches, homes. The corporate bullies like Texas Central, these are merely words, dots on a map, lines on a plat. This company thought it could come in and run roughshod over rural Texans without consequence. What it vastly underestimated was the determination and devotion with which we have prevailed against them at every turn. See, for us, it isn't just about the dirt and rocks or the trees or the cattle of the pasture land. It's about family.
It's okay, Barbara.
Family, friends, sweat, sacrifice, responsibility, and history. It's about pledging to be good stewards of the land as long as we have it, and defending that pledge at all costs. Being the face of this lawsuit has taken its toll on us in a number of ways. Yet, given the opportunity, we would do it again in a minute. Taking a stand against this company and the threats that it poses is that important to us. However, we could not have achieved this win without the unerring support of Texans Against High-Speed Rail, the outstanding legal representation provided by the Beckham Group, and the tremendous efforts of those who saw the fallacies of this project and gave so generously and tirelessly to ensure the fight against Texas Central continued until victory was achieved. We share this moment with all of you. It is our hope that the outcome of this case will serve as an inspiration to all of those who think that corporate muscle outweighs any chance for the everyman voice to be heard. We are being heard today, and the message is loud and clear. Pack up and go home, Texas Central. There's no place for you in rural Texas.
At this time, I'm very honored to introduce District 13 State Representative Ben Leman. As most of you know, Representative Leman and I formed Texans Against High-Speed Rail over 4 years ago, when he was serving as then Grimes County Judge. Now, as a state representative, Ben is fighting the good fight for us in Austin, along with all the other members of the Texas legislature who all recognize the damage this project would cause and have vowed to do all they can to stop it. Representative Leman.
Thank you, Kyle. Good afternoon or good morning. Not sure which it is right now, but first I would like to thank Mr. and Mrs. Miles. I sincerely appreciate you having the courage to endure the years of pain and suffering inside this courtroom and outside of this courtroom, only to secure the victory on what was rightfully yours from the very beginning, your private property rights. Mr. and Mrs. Miles, along with all landowners being affected by this project between Dallas and Houston, deserve better than this. The bottom line is this: in no way, shape, or form should a private entity be able to falsely claim to be a railroad, falsely claim to have the power of eminent domain, and then under that false pretense be able to terrorize and threaten hundreds, if not thousands, of landowners with lawsuits. They should not be able to pressure landowners by being able to actually file lawsuits on that false premise. They should not be able to execute option contracts under that false pretense to purchase people's land that are scared and terrified of being dragged into the courtroom under that false pretense. There should be absolutely, positively, no question as to which projects have eminent domain and which projects do not. This terrible abuse of eminent domain might be how things get done in the foreign country pushing this project. But this is not how we do things here in the state of Texas. We don't terrorize our citizens this way. We don't trample over one of our most prized possessions that is the absolute cornerstone of our freedom in this country, our private property rights. As former Grimes County Judge, I have been front and center on this issue and working to defend the private property rights of our citizens for nearly 5 years. During that time, I have learned one thing is clear about high-speed rail projects in Texas: the framework, the structure, the guidelines, The process by which a project like this goes through in effort to attempt to get constructed is completely broken, and it needs significant and meaningful improvement. It is time the state of Texas steps up to protect our citizens from this ever happening again. In the upcoming weeks, I will unveil the bills I will file this legislative session that will address these precise concerns. Many of my colleagues have already introduced bills. I look forward to having this discussion inside the Capitol and providing permanent solutions that protect the private property rights of all citizens across Texas. Again, I thank Mr. and Mrs. Miles. I thank Blake Beckham and Patrick McShan with the Beckham Group. I thank Kyle Workman, Chairman and President of Texans Against High-Speed Rail. And I thank these two fine judges next to me, Judge Trey Duhon of Waller County, and my own judge in Grimes County, Joe Fouth. Thank you very much. I appreciate that.
Thank you, Ben, and again, this is an honor to share this moment with you. Thank you for your commitment and tireless efforts to protect private property rights here in Texas. Again, today marks a turning point for the private property rights of all Texans in the crosshairs of this disastrous pipe dream of a proposal. For the last 4 years, this promoter, it's a promoter, Texas Central, has misled and manipulated the media, governmental agencies, landowners, and state leadership. They have bullied anyone who dares question their fabricated ridership estimates, expose their tactics, or reveal the truth. Today, I call for all of these shenanigans to stop. Texans Against HSR has repeatedly asserted that simply self-declaring that you intend to be a railroad, or an interurban electric railway for that matter, does not make it so. This week, the court unequivocally agreed. In 2016, a Harris County court rejected TCR's arguments and denied survey access. TCR stated they were looking forward to their day in court, and then subsequently dropped their lawsuit. Recently, an Ellis County court denied Texas Central's request to be declared a railroad, thus blocking survey access in that jurisdiction. TCR again stated they were looking forward to their day in court. Now, with this latest ruling, they had their day in court. 5 of the affected counties have orders denying TCR's claims. Let me be clear, anywhere TCR has been challenged, their arguments have been rejected by the courts. It is important to note that this most recent ruling is based on the merits of TCR's case, and a final order has been issued. Again, TCR had their day in court. They're not a railroad company or an interurban electric railway, and they do not have eminent domain authority. TCR will likely appeal, but make no mistake, these legal actions will take years, and we stand, all of us, ready to take this all the way to the Supreme Court. One thing that is now undeniable, the laws of Texas do not give this project authority to condemn property or even to survey private land without landowners' express consent. Rather, it protects the private property rights enshrined in our Constitution. Without eminent domain authority, there is simply no track forward for this project, either for construction or permitting. I, too, commend Jim and Barbara for having the courage to stand up to the mafia-style bully tactics that TCR and its consultants have used. While this case has been about the Miles private property, this has been a shared fight across county lines, blurred urban and rural, and solidified the resolve of thousands of Texans who, as Mr. Miles puts it, will see this through to the end. Throughout history, Texans have been called to stand up and fight. As we all know, this moment in history is one of those times. Finally, I want to thank all of our elected officials for the support and commitment to protecting their constituents. I cannot mention them all. I wish I could. The Representatives Ashby and Leman, along with Senator Schwartner, have been a part of the group of legislators who are leading the charge in Austin. I cannot thank Congressman Brady enough for his unwavering commitment to oppose the project, along with Judge Ryder and the Leon County Commissioners who have been steadfast in their opposition as well. Leon County Judge Byron Ryder is out of town, and as the Leon County Special Advisor on High-Speed Rail, he asked me to read this statement from him. I am disappointed I am unable to be there with you, but I am pleased with the ruling. Two things are now clear. One, Texas Central cannot and will not be granted the necessary permits to perform any work on Leon County property, including their rights-of-way, which require the proof of eminent domain authority to secure. And two, there will be no high-speed train through Leon County in the foreseeable future. Leon County Sheriff Carinellis also asked me to read a statement on behalf of him related to trespassing. There is now no question about the status of TCR's claim of eminent domain or qualifications as a railroad. Consequently, the Leon County Sheriff's Office will continue to enforce our zero tolerance policy as it relates to trespassing related to this project. If you have any concerns about trespassing, please contact the Sheriff's Department. Thank you. And finally, the Leon County Attorney, James Caleb Henson, shared this statement regarding his handling of cases in the future. Being descended from many generations of Leon County farmers, ranchers, and landowners, I hold private property rights as inviolable. Leon County has elected me as the county attorney, and one of my responsibilities is to defend those private property rights through the prosecution of violation of Texas Penal Code 3005. That statute defines trespassing as a Class B misdemeanor punishable by up to 180 days in the Leon County Jail and a fine of up to $2,000. My office will prosecute any violation of these private property rights to the fullest extent allowed by law. In conclusion, this has been a long 4 years. As soon as the public learned of this proposed HSR, those of us who were directly impacted began to look closer at the details and decipher the misinformation and propaganda promulgated by the promoter of this proposed project. It quickly became abundantly clear that this company was misrepresenting itself to hundreds of landowners, both those they were approaching for survey access and then those whom they were negotiating option contracts. Even more striking is that they were also misleading and bullying the media and their elected officials. We have known all these years that you can't just say you're a railroad and secure the rights, the privileges, and the authorities of a railroad. Now, thanks to Jim and Barbara Miles pushing back on the promoter, and to the Beckham Group for their excellent arguments, the legal status of Texas Central and integrated Texas logistics have been made clear. They are not a railroad or an interurban electric railroad. TCR can no longer railroad us, deceive us, or destroy our state. Thank you for being here today. And with that, we are happy to take questions at this time.
I'll start out with you, sir.
Yes,
Just as we get a response from Texas Central later, I haven't got to speak with them directly just yet, but if they maybe downplay the significance of this ruling, just your thoughts on if they say that the train is still going to be built from down.
Well, they're going to continue to maintain that because that's what they have to do in order to keep their money flowing, right? I mean, as soon as anybody figures out how severe of a victory this is for them, then that may shut the spigot off. In reality, an appeal will take years, many years, and like I said, we intend to take it all the way to the top. So, they can continue to say that things are going forward, and they can continue to pretend, and they continue to pay people like David Benzian here to pretend that they're moving forward. But in reality, they're not going to be moving forward in Leon County, Limestone County, or Freestone County anytime soon.
Kyle, let me add to that in Texas, if Texas Central responds and says we want to downplay, if Texas Central says we want to downplay the ruling, Texas Central's own legal filings and briefs repeatedly state that eminent domain is essential and crucial for them to build this project, and without it, they can't build the project. So if they take that position, once again, they'll be speaking with forked tongue.
Good point. Thank you. Anybody else? You have any more?
Sure. I'll ask you too, just for the fight, you mentioned you're willing to fight all the way to the top. Do you see maybe kind of a closer picture to an end being in sight now with this ruling here in Leon County, or do you think in the next couple of years then maybe a final resolution one way or other, just going forward, kind of the plan addressing that?
Well, obviously, it's not up to us at this point, right? I mean, Texas Central has the next move. At this point, they can't do anything. Effectively receiving, a death sentence for eminent domain use in these counties. But, we don't know what the future holds. We just know what our resolve is. And all the resolve of the people in this room and all the thousands of landowners between Dallas and Houston who need to hear the truth. And the truth is that in spite of their propaganda to the otherwise, they are not a railroad and they cannot condemn your property.
And as far as our next steps, Texas Against High-Speed Rail will immediately be taking this ruling to both the Surface Transportation Board in Washington and the Federal Railway Administration, informing them that under Texas law, Texas Central is not a railroad company and does not have eminent domain. Texas Central has represented precisely the opposite to all relevant federal agencies, and we will be instantly correcting that misinformation.
And one of the things I'd like to point out is that this access to these properties is more important as important now as it would be in the future at the time of construction, because in order for you to proceed forward with the permitting, you have to have access to these properties. You can't secure a permit on property that you don't own and you can't own. And I think that's going to be a huge hurdle as they go forward, not only in the construction side, but also in the permitting side. Yes, ma'am.
That also means if they cannot do surveying from the air, they have to have feet on the ground, correct?
It is our understanding from both the Federal Railroad Administration and the U.S. Army Corps of Engineers that they will have to get on the properties prior to being issued a permit. So, one thing I want to point out that Judge Dewan super pointed out, I mean, this fight is not over. Okay, we got to continue to do our diligence, contacting our legislators, supporting our local officials, and to continue our fight. This is a huge victory. But the war is not won. The battle is won. It's a significant battle, but it's not over. So we got to continue to do what we've been doing, and our resolve must remain steadfast. Yes, sir.
What about the environmental impact study that was done? Preliminary, and then they're supposed to be doing the final.
Right. The question is how does this affect the draft environmental impact statement and ultimately the final impact statement? Pursuant to what I was talking about earlier, we consider that part of the permitting process, and it's our understanding that they're going to have to get on these properties at some point in order to get the final EIS issued. The draft EIS was done based on a lot of desktop work, if you will, but there's a lot of properties that they will need to get on physically that they cannot do at this point. So.
I have a question. If they
Yes.
try to get on, like, sue, say us again, with this ruling, would they even be allowed to continue on in that route? In that manner? Like, if
There's
they try-
9 counties that are affected. 5 of them have issued rulings against Texas Central so far.
Right.
We are monitoring Texas Central's activity statewide, and we will show up instantly wherever they are with a stack of rulings from all these judges, and encourage any judge in the county where there has not yet been a ruling to follow the precedent set by these other counties. Any other questions?
For those landowners who have initiated contracts with Texas Central and are expecting to receive a balance of payment, how's that gonna impact? What's gonna happen there?
Well, that's a great question. We've had many calls already from landowners who signed option contracts that want to know how they can get out of the option contract, because The only reason they signed the option contract was they were pressured and bullied and intimidated and told, you better sign now because you're going to lose in court. We have eminent domain. And so I would imagine there's going to be some significant outcry from people that signed those option contracts that are going to want relief.
Thank you.
I have a question.
Yes, ma'am.
Our friends from Houston and Dallas continue to talk to us about Texas Central saying that they are going to start construction at the end of this year. I hear that all the time. What are you doing? You know, what, are you still fighting it? Like, yeah. Either people think it's not going to happen at all or it's a done deal.
Right.
So how, I mean, in fact, the EIS hanging out there, yet they're saying they're going to start construction.
Well, the important thing to note is that the EIS is only one piece of a huge puzzle together for them to start, right? Not to mention the $20 billion they have to find, right? So, you know, the draft environmental impact statement will ultimately, if they reach a record of decision, is only one step in the right direction. We have the rule of particular applicability. They have to get that in order if they can run the train, right? It is completely implausible that they would be doing any work on the project on the ground by the end of this year. But they continue to do that because that's the narrative that they have to put out, right? And if you, for those of you who've been around with us for the last 4 years, at first they were going to start in 2017. Then it was 2018. Now it's 2019. And then if you listen very carefully, now they're starting to shift a little bit and they're saying, well, we're going to have service running in the mid-2020s, right? Which means they're going to start sometime around 2020, 2021 with a 3 or 4 year construction time. So you just have to watch. What I find is that the vast majority of people aren't paying that close of attention. They just get little snippets, and so they're not keeping track of it like most of us are.
I think our friends are keeping track of it for us because
Yeah.
you know, we get calls like, oh my gosh, it's a done deal, what's happened to you? I'm like, it's
Well, the people in Dallas and Houston understand money. The people in between understand land and landowners' rights. So if they don't understand abuse of eminent domain, just tell your friends in Dallas and Houston, they barely have 1% of the $20 billion they need, and they've spent most of that, and they've lost every single legal interaction, federal or state, regulatory or court. Now, how's a broke company going to build a $20 billion railroad? And if they still don't believe you, haven't called me.
Anything else? Anybody? Well, again, thank you very much for your time. Thank you for coming, and thank you for your continued support. Have a safe trip on the way home, okay? Thank you.